Consumer guarantees. In addition to the general prohibitions and the specific prohibitions contained in the Australian consumer law and described in earlier videos, the Australian consumer law contains a number of consumer guarantees. These guarantees are implied into contracts for the sale of goods involving consumers. We saw in Topic 5 and Topic 6 that a contract for the sale of goods is very simply a contract involving the exchange of goods for a monetary price. A contract for the sale of goods is by far the most common type of contract that we enter into in our daily lives. The Australian consumer law implies into contracts for the sale of goods to consumers guarantees that the seller has title, the consumer will have undisturbed possession of the goods, and there are no undisclosed securities over the goods. These consumer guarantees replicate the terms implied into contracts for the sale of goods by the sale of goods legislation, and in particular those implied terms relating to title. The Australian consumer law also implies consumer guarantees that the goods are of acceptable quality. This is very similar to the implied term regarding merchantable quality that we looked at in Topic 6. There is also a consumer guarantee that the goods are fit for any disclosed purpose, and this is similar to the implied term regarding fitness for purpose that we looked at in Topic 6. There is a consumer guarantee that the goods correspond with their description, and again this is very similar to the implied term regarding correspondence with description in the sale of goods legislation. And there is a consumer guarantee that the goods will correspond with any sample or demonstration model in quality, state, or condition. Again, very similar to the term implied by the sale of goods legislation. There's also an extra couple of consumer guarantees imposing obligations upon manufacturers. So there is a consumer guarantee that the manufacturer will ensure that repair facilities and spare parts are reasonably available, and a consumer guarantee that the manufacturer will comply with any express warranties given in relation to the goods. Unlike the sale of goods legislation, the Australian consumer law also grants certain protections to consumers when they engage in contracts for the provision of services. The sale of goods legislation is limited to protections in relation to contracts for the sale of goods. So the Australian consumer law implies into contracts for the supply of services to consumers guarantees that the services will be rendered with due care and skill. The services and any product resulting from the services will be fit for any disclosed purpose, and the services will be supplied to the consumer within a reasonable time. The other important difference between the Australian consumer law consumer guarantees and the terms implied by the sale of goods legislation is that the consumer guarantees cannot be excluded. The protections granted by the sale of goods legislation can be overridden by the terms of the contract between the business and the consumer, but the terms of the contract cannot override and cannot exclude the protections that are granted by the Australian consumer law. This means, for example, that a sign such as this in the premises of the business stating that consumers are not entitled to a refund is of no legal effect. The Australian consumer law grants to consumers a right to a refund when the business provides a consumer with goods that are not consistent with the consumer guarantees. Now, a sign that says no refunds except when required by law will be okay, but a sign that simply states no refunds and an insistence by the business that the consumer is not entitled to a refund in any circumstances is inconsistent with the Australian consumer law. In fact, a sign such as this is more than just of no legal effect. It is in fact misleading and deceptive, because it is telling consumers something about their rights that is simply not true.